Okay, so we are working on problem 3, and it is now, we're going to dive into, as I mentioned the other day, the area of this particular unit where we get a whole lot of law. Okay, so we're back into the federal statutes and so forth. In the other, the subsequent topics that we're going to be studying definitely involve some law, but this is like heavy statutory, regulatory type of stuff. Okay, so the topic today is RCRA, CERCLA, and brownfields. Okay. RCRA is the Resource Conservation Recovery Act. One of the things I'll just mention from the outset here is that both of these statutes were pretty bread and butter in my environmental practice in Texas when I practiced environmental law. And I continue to deal with them in various rules in government task force, nonprofit organizations, and that kind of thing. But this is definitely, these two statutes are ones where I gave a lot of clients a lot of advice and guidance about how to navigate them and so forth. So important area of law to master if you're going to do any kind of environmental law. So RCRA is a statute that is about management of waste. And it is really a cradle-to-grave regulation of waste. That's what whatever he calls it, cradle to grave, which basically means from its generation to its disposal, all the way through. So this is the first federal statute to ever do an entire life cycle approach to regulation. The statute has 4 primary goals, which are to determine the classes of waste coming under RCRA authority, create and implement a tracking system for hazardous waste from its creation to its disposal, again, that life cycle approach, to establish handling standards for waste from generation to disposal, and to provide mandatory authority for cleanup of polluted treatment, storage, and disposal facilities. Now, the statute does more than that, okay? So do not limit yourself in your understanding of RCRA to just these 4, but these are 4 sort of primary things that were on the mind of Congress when it created RCRA. One of the things about RCRA is it looks like it's extremely broad. Okay, from the very outset, it looks like it potentially covers pretty much just all waste of any sort. And then what you find is that while there are aspects of the statute that do cover non-hazardous waste, okay, and also some aspects of the statute that cover liquid waste, the primary focus, or where a lot of the attention is in what's called subtitle C, which is solid hazardous waste. Okay, so that solid hazardous waste gets a whole lot more attention. Okay, so let's start with RCRA regulates solid waste. Okay, so starting point of the statute is regulate solid waste. And like you might expect by now in law school, when we say solid waste, that's not what we mean in the slightest. It is not limited to solid. It is basically solid waste is defined by statute, right? You let a bunch of lawyers and members of Congress get together and they define solid waste to include garbage, liquid waste, solid material, other discarded material, contained gases, leachate, okay, all sorts of things. Okay? So it can be liquid, it can be gaseous. Okay, so even though the statute on its face is solid waste, the definition is so broad that it includes other things. Okay? And leachate, by the way, there's some attention to it in the book, but it's basically where you have water that is somehow percolating through or flowing through waste. So think about what's happening at this very moment with all that rain outside that is falling on landfills, okay? And those of you who did not recycle your batteries, but instead threw them in the trash, okay, right? And so forth. And those are sitting in the landfill somewhere, and that cadmium and nickel and so forth that's in the batteries is leaching out of those decomposing batteries into the groundwater, right? And so leachate is where the water percolates through and it picks up various contaminants along the way. Okay? And so all of that is regulated. RCRA also regulates underground storage tanks of petroleum and other hazardous liquids, such as solvents and pesticides. Okay? So gas stations, these big tank farms where you have natural gas tanks or oil, gasoline, that's going to be for getting picked up by the tanker trucks and taken around to the various gas stations. All of that ends up being subject to RCRA regulation. We will see later that oil and natural gas are expressly excluded from CERCLA liability. Okay, so that's going to be one of the things you might start confusing in your mind. Okay, so oil and gas is, when it's in underground storage tanks, subject to RCRA regulation, but when we're talking about liability for contamination, petroleum products are largely excluded from CERCLA liability. Okay, so just put that out up front, so you have to distinguish between the two. So the idea here behind the provisions regarding underground storage tanks is to avoid groundwater pollution, and the statute expressly includes a fund, creation of a fund to address leaking underground storage tanks. Leaking underground storage tanks, which are called LUSs. And when this came about, when this particular provision got enacted, you can imagine that lawyers who are nerdy and especially if they do environmental law, it's all very technical, you can imagine the joy they had in having CLE programs about lust. Okay, right? So it tells you that they have very sad lives. But nonetheless, that if you go out there, people refer to lust, that's what it's about, leaking underground storage tanks. And it's a problem. It's a serious problem. Okay? There are many, many older gas stations out there that have leaking underground storage tanks, right? Those tanks are very old, they deteriorated over time, they did not use the technology that's available now, right? So now we use secondary and tertiary containment procedures for underground storage tanks, but older facilities did not, and so forth. Next issue we want to ask is the waste in question, is it a part of the waste stream or not? So this has become the subject of a fair amount of litigation. You saw several cases that were discussed in the reading about the exemption for recycling. Okay, so basically the idea is the statute wants to encourage the recycling of waste, the reuse of waste, okay? But it does so only if there is some ongoing process for that, and that it is being put to or made available for immediate reuse. Okay, so what does that mean? It means that this is really about industrial processes. Okay, so you've got an industry and they've got waste coming off of their industrial processes, but they can reuse that waste. They can put that chemical back in the system. Okay, one of the issues that used to come up was, well, when they have that coming off of their system and they're storing it in some storage drum, some big storage drum and so forth, until they can put it back in the system. Is that subject to RCRA? And the answer is no. The answer to that is no. But if, on the other hand, what you're talking about is the stuff that you put out at the curb in what's called recycling, okay, that is not considered recycling for the purposes of RCRA coverage, or what's subject to RCRA, because you basically are putting it in the waste stream, right? Okay, so it's not like, okay, so just think about this. Like you get a paper bag from the store, from the grocery store, and if you put it in your cabinet to reuse for taking your luncheon, this week or something like that, or next week, okay, that has not entered the waste stream. If, on the other hand, you put it in the municipal recycling bin, it has entered the waste stream and it is subject to RCRA. Now, RCRA doesn't care about your paper bag for the most part, okay, before we get to that, okay? But if, on the other hand, instead of your paper bag, it's some sort of hazardous substance, then again, the key is your exemption only applies if it's an ongoing process and it's available for immediate reuse. And immediate does not mean in the next 60 seconds, does not mean in the next 90 seconds, but it also means you're not just storing it for some lengthy or indefinite period. Then the next issue is the waste in question exempted by statute? And as your book points out, this is one of the kind of weird things about RCRA is that here it's supposed to regulate all waste, and then they have these big, huge exemptions. So point source discharges into waters are not subject to RCRA regulation. This is actually one of the key legal aspects as to what's going on with the regulation or non-regulation of coal ash waste. Okay, so if you just read the news, you get the impression that neither the federal government nor the courts want coal ash waste to be regulated. What the Sixth Circuit and Fourth Circuit have said, though, is that the lawsuits that were brought before them had to do with regulation of coal ash waste that ended up in waterways. Okay, so one of the big ones is Kentucky Waterways Alliance. Okay, so right here in Kentucky, it's Kentucky Waterways Alliance case. And what the court said is that Congress made it very clear that it has an entirely separate regulatory regime for point source discharges under the Clean Water Act and regulation of solid waste under RCRA. And so they said coal ash waste is subject to RCRA, and then there's also there's a special coal combustion rule that the EPA adopted, and they sort of said, hey, that's how you're supposed to regulate coal ash, not under the Clean Water Act. Well, the reverse is true. Okay, things that are regulated under the Clean Water Act are not regulated under RCRA. Okay? Right? So if you've got a industrial facility and it has an NPDES permit to put a bunch of pollutants into the waterway, it's subject to EPA regulation through the state, but under its NPDES permit under the Clean Water Act, not under RCRA. Domestic sewage, also not subject to RCRA. That also, as you know, is subject to the Clean Water Act. Mining waste, nuclear waste, those sorts of things. All right, next, when we talk about RCRA regulation, again, we're talking about solid waste, but one of the big questions is it hazardous waste? Okay? Is it hazardous waste? If it's hazardous waste, it is subject to Subtitle C. The bottom line is if you represent any client that might have some sort of waste and they're asking you for some sort of advice or analysis or help with their legal problems, your client desperately does not want to be subject to Subtitle C regulation. It's significantly onerous. And so they would much prefer to either be exempt altogether, or if not exempt, then subject to Subtitle D, which is non-hazardous solid waste. So that's an issue. Something I went through this a lot, this basic analysis a lot in practice, kind of working my clients through this. So is it a hazardous waste? There are two categories. One is the category of listed hazardous waste. These are waste that the EPA has identified as hazardous pursuant to notice and comment rulemaking and have been published first in the Federal Register and then codified in the Code of Federal Regulations, CFR, right? So you can find out exactly which ones these are by going to the CFR, right? And that's how it's got. So these are ones where the EPA has determined on the basis of the science that these are hazardous substances. And there are two additional rules that go with this, okay? So that it's not only the hazardous substances, but also hazardous substances that are mixed with non-hazardous substances. Hazardous substances that are mixed with non-hazardous substances. That is the mixture rule. Okay, so that is going to include, for example, leachate. Okay, so when we talk about leachate, it's a problem, right? Because you've got rainwater, but now it mixes with the hazardous substance and goes into the groundwater. It's a problem. It also includes what we call derivatives, or things that are derived from a hazardous substance. That's called the derived from rule. So if it was hazardous and you extract things from it and so forth, it remains considered hazardous even if it's not, it doesn't really have any hazardous characteristics. It is, even if it's not physically or scientifically or chemically not hazardous, it is legally hazardous. That makes sense? Okay, right? Well, your book, your reading for today, points out you get a lot of ridiculous outcomes from how these rules operate, right? You have these big, huge exemptions. Nuclear waste is not subject to RCRA, but some scientifically non-hazardous derivative of a hazardous waste is, right? So that's part of where they're coming from. That's what they mean when they say you get these outcomes that are sort of a little illogical, okay? But the thing is that there are reasons for these rules, in part because it just needs some bright line rules, in part because it is a system that requires tracking, right? And so it's hard to go in and out of the tracking, right? And so forth. And so, but also in part, this is the scheme that Congress has come up with. The second kind of category of hazardous waste are what are called characteristic waste. These are wastes that even if they do not appear on a list in the Code of Federal Regulations, if they have certain hazardous characteristics determined by flammability, corrosiveness, reactivity, and toxicity. And I cannot tell you how many times in practice I went through these 4, types of characteristics, these 4 categories of characteristics with clients. And the client flips out because they say, well, why can't you tell me whether whatever bad stuff I'm producing falls in this category? And the answer is because you actually have to have it tested to see whether it has these flammable characteristics, these corrosive characteristics, these reactive characteristics, and these toxic characteristics. Okay? So there is a rule, it's a law-based rule, but the actual determination about whether a substance falls into that category or not is a purely scientific, technical determination. You have to do actual tests. Okay, so you know, unless you happen to have a PhD in chemistry or something, generally, I hope you're not telling your client, yes, this is a characteristic waste. Instead, what I hope you're telling them is, okay, these are the tests that have to be applied. This is what the standard is. You need to send it to the appropriate lab to determine that. Okay, and that's exactly how it works. I guess this stuff gets tested in the lab. Okay, but the good news for your client is, unlike listed hazardous waste, if the substance at some point loses its hazardous characteristic, it is no longer hazardous. It gets to drop out of the system. Okay? So that is, you know, it's probably not much of a consolation to your client, but it's one. And I know, problem number 3, that's not the kind of client we're talking about, but just, you know, as you think about practicing law, that's one of the issues. If the substance is not a listed hazardous waste or a characteristic hazardous waste, then, but it nonetheless is a solid waste, the less onerous Subtitle D regulation applies. Municipal waste, which we tend to think of as garbage, is treated under the statute expressly as non-hazardous. And that's true even if there are small amounts of hazardous substances in it. Okay? So like I mentioned before, you know, people throw their batteries in the trash. They're not supposed to. It's bad. But nonetheless, Congress has decided that it is not what they want to do to try to regulate every landfill of every city in the United States as if it's a hazardous waste site. Okay? That's not the issue. Now, having said that, okay, that is only under RCRA. If there's enough hazardous waste in a landfill that creates contamination under CERCLA, then the municipality may very well, actually will be, liable under CERCLA for the cleanup. Okay, so that's a different, right? So, right, we're just differentiating these 2 statutes in our mind. There's RCRA and there's CERCLA. RCRA is a regulatory statute. CERCLA is a liability statute. And we're going to see when we get to CERCLA that it's much more expansive. It includes more things. Okay? So, but basically, the local landfill is regulated under Subtitle D, but it is a less onerous amount of regulation. Okay? Right? So, who gets regulated? 3 categories: generators of waste, transporters of waste, and TSDs, treatment, storage, and disposal facilities. Generators, transporters, and TSDs. The book points out that the most significant amount of regulation, the most responsibilities, are on TSD facilities because they're the ones that there ends up being contamination and leakage and bad stuff that happens. Generators are the second most regulated because, of course, they're generating the stuff. Transporters are somewhat regulated, but they are mostly regulated in terms of how they handle it, how they transport it, labeling, following the hazmat routes, etc. Right? When you see the signage, right? All this, you know, hazmat stuff, and there's certain like tunnels you can't go in if you're carrying hazardous substances, right? And so, right? I mean, so, and I think weren't they doing that with all the I-64 construction that you couldn't go that way, right? And so forth. So that's all subject to federal regulation under RCRA. So we start with generators having to classify the waste when it's created, right? So we're talking about cradle to grave. The waste gets born. Okay, it has to get named, it has to get classified, right? Birth certificate, right? So, it has to be labeled and tracked. That means there's a manifest system, okay? And I mean, really, this is a very in-depth, highly monitored, highly recorded system. So presumably, the regulators for sure, and actually many people, can determine exactly what hazardous waste is, you know, how much of it there is, where it is, at any time, all the way from the point at which it's generated, all the way through the point at which it's disposed of. And then while it is disposed. So, you know, I guess until it totally disappears from the environment, we have a way of tracking it through the manifest system. And there are record-keeping requirements. And does that mean that nobody ever fails to do this? No, of course not. There are people who do not do what RCRA requires, okay? At that point, either your expertise needs to be the intersection of environmental law and criminal law, or you need to find a colleague who does criminal law, because if there are generators, transporters, or TSD facilities that are not doing the tracking and the record keeping and using the manifest system, the EPA is most unforgiving about that. Okay, so because the idea is we want to know where it all is, okay, and so forth. So that's part of the system. Then there are a variety of standards, regulatory standards, that apply to the storage of waste. And they're relatively technical. I don't think that's especially important for us. The general gist is, of course, the idea is to require anybody who's storing hazardous waste to store it safely, store it in a way that is not going to lead to leakage and contamination and exposure of humans or the environment to that waste. I mentioned the transportation requirements. There are a variety of requirements related to transporting waste. Again, labeling not only the waste, but also labeling the transportation vehicle. So again, right, you see the hazmat, you know, kind of signage on vehicles and so forth, and how and so on and so forth. Again, think about this manifest system and this record keeping, right? You've got bad stuff on a truck moving through your community. Okay, one of the things is first responders need to know exactly that, right? They need to be able to tell instantly what exactly it is, where it is, on what truck it is, what you etc. Right? Does everybody see that? Right? I mean, that's exactly part of what this is. There's a whole other statute that we're not getting into too much called the Emergency Planning and Community Right to Know Act. It's EPCRA, and it deals with sort of sharing information with the public and some emergency response kinds of things, but they sort of intersect. The regulatory standards impose a variety of standards that are aimed at clean operations of these facilities, but basically, again, non-contamination, anti-contamination, and to make sure that when the facilities are done operating, the closures or shutdowns are clean, right? That we don't have any contamination. If there is any, it gets cleaned up, and so forth. And there is supposed to be monitoring for pollution and contamination. And finally, all this is implemented through a permit system. The permits are primarily for TSD facilities. Okay, so TSD facilities are heavily permitted. So one of the things that is important from an environmental justice perspective is you can find through the EPA's database exactly where all the TSD facilities in your community are. Right? They're permitted, their location is identified, and there's something called, there's an EJ mapping device where there was actually, I forget how old it is, but it's been the last decade or so, that basically you can, it's a mapping system where you can take, say for example, low-income characteristics, racial and ethnic characteristics of the population, TSD facilities, and so on and so forth, and layer them and create maps to show where these are. And as you might expect, there are disproportionately higher number of TSD facilities in low-income communities of color, and the census tracts that have higher percentages of low-income people, higher percentages of people of racial and ethnic minorities than in the other census tracts. Okay, so that is pretty clear-cut, and we're going to get a little bit more into that when we talk about environmental justice. But part of how we're able to assess that and monitor that has to do with the RCRA in the way that it is very information gathering, information monitoring intensive. So some more stuff on how it works. So I've already talked quite a bit about the cradle-to-grave tracking system. That's huge. That's very important. The law also has embedded in it some directives aimed at reducing waste, reusing waste, recycling waste, and then only then should it go to the landfill. Okay. Having said that, this particular aspect of the statute is less effective. Okay, so less effective. The reduce, reuse, recycle, and then landfill part of the statute is less effective. The statute uses permitting and permit systems to regulate the activities and behavior of the regulated community, of the waste generators, the waste transporters, and the waste storage and disposal facilities. There is a ban on hazardous waste in landfills. That's called the land disposal ban, and that is an important piece of this because that was not always true. Right before RCRA came along, a lot of hazardous waste got just dumped in landfills. And so you have your local municipal garbage, and you have big bad chemicals and stuff being dumped in the same landfills, and that was not good. So that was a key development. We do know, however, that landfills do have some hazardous waste, and that does not take them out of Subtitle D, and it leaves them there. But part of the Subtitle D requirements, though, is that the landfill operators have to follow certain, incorporate certain pre-treatment standards to prevent groundwater contamination. Okay, so this is called the no migration rule. Okay, so think about this, right? You've got all that stuff in the landfill, that garbage, and so forth. And the question is, what's going to be done to prevent, when again, like this rain that's going on now, to prevent that from getting out to the groundwater? Okay, so there's a variety of things. There's various kinds of liners. Okay, so there's clay liners, there's plastic liners, and concrete liners. There are various kinds of things that have to be used in landfills to try to prevent groundwater contamination. No migration rule. The lust funds are also important because think about the leaking underground storage tanks. What are we talking about? We're talking about gas station. We're talking about a number of things. It could be, for example, pesticides in some places that had a bunch of underground storage tanks with pesticide, big amounts of pesticide stored there. But just think about the typical gas station that closed down 30 years ago. Okay, right? Those tanks are old. They're going to be leaking, and who knows who owns that gas station? They may no longer be in business. They may no longer have any funds available to deal with it. And so what's happening? Local groundwater supplies are being adversely affected, and there's really nobody to do anything about it. In addition, if it's petroleum, it's exempt from CERCLA liability. So there's nobody put on the hook under Superfund law for cleaning it up. So part of the idea is these lust funds are meant to address this so that you don't end up, there are federal funds available to get in there in a kind of emergency situation and stop the leaking from happening and get all that cleaned up. There are state plans that are, so basically states have to have plans for how landfills are managed and operated, and they can adopt regulations if the regulations are consistent with federal regulation under RCRA. And so the book refers to this as cooperative federalism and so forth. It's a little more complicated than that because because while theoretically states can regulate more stringently than RCRA, the consistency requirement has at times been interpreted to basically invalidate state regulations that were more restrictive under the theory that their more onerous regulations are not consistent with federal standards. So it's so yes, there's some cooperative federalism going on there, but it's a tricky act if you are a state government or a local government and you're trying to regulate waste sites. And we're going to talk about preemption in just a moment. Okay, so another mechanism involves corrective actions that require the cleanup of contamination, and then, so we're talking about that in just a moment, I'll just list it here. And then finally, one of the things that's sort of a problem with RCRA, one of the limitations is that it doesn't really facilitate or incentivize the production of less waste. There's no real strong mechanism there that really means we're going to produce less waste, and so that's a challenge. Okay, so there are some EJ issues with RCRA, and several EJ issues that are, first of all, highly relevant to problem number 3, and then also raise some interesting issues. Okay, so first of all, there are questions about citing these facilities. Any of the facilities are subject to RCRA regulation. So obviously, even though landfills get less regulation they get some regulation under Subtitle D of RCRA, and they are again disproportionately cited in low-income communities of color. I'll start referring to them as EJ communities. Okay? TSD facilities for hazardous waste. I've already mentioned they are disproportionately located in EJ communities. One of the other big issues that has come up in the environmental justice movement has to do specifically with hazardous waste incinerators, where there's an intersection between RCRA and the Clean Air Act. Okay, so while there are entirely separate regimes between RCRA